And now we will like to welcome our expert and esteemed panel that have come with us. I want you to know that you're the finest panel that ever assembled before us this morning, all right? And we recognize you so much, and we thank you so much for being here with us. I want to recognize from my left to right, beginning with the Honorable J. Thomas Rush, who's a commissioner of the Federal Trade Commission. We want to recognize you, Commissioner Rush. I think that's how you pronounce your last name. Thank you so much. Next to him is Mr. Scott Hemphill, who is an associate professor of law at Columbia University. Welcome, Mr. Hemphill. Next to Mr. Hemphill will be Ms. Joanne Handy. She's a board member of an organization I just recently joined, the AARP. Welcome, Ms. Handy. Next to her is Ms. Diane Beery. She's a general counsel for Pharma. Welcome, Ms. Beery. Next to Ms. Beery is Dr. Barry Sherman, who is the Chief Executive Officer for Apotex Incorporated. Dr. Sherman, you've been here before at this committee, and we welcome you once again. And next to Dr. Sherman is Mr. Ted Whitehouse of the firm Wilkie, Farr, and Gallagher, who's been before this committee before, and he's here on behalf of Teva Pharmaceuticals. We certainly want to, again, welcome each and every one of you, and thank you for taking out moments from your important day to be here with us. And now we will recognize Commissioner Rush for 5 minutes for the purposes of an opening statement. Turn the mic on, please. Put it closer to you.
Okay. I appreciate the chance to appear before you today. The written statement that we submitted represents the views of the Commission as a whole. My oral testimony is my own, and it doesn't necessarily reflect the views of any other commissioner. There are several compelling reasons why it's imperative that Congress enact legislation in this area. Reverse payment agreements strike at the heart of the special statutory framework Congress created in the Hatch-Waxman Act. That framework was designed to balance two policy goals that are critically important to the pharmaceutical industry. Hatch-Waxman gave branded companies a longer patent life. The trade-off was that generic companies were given a strong incentive to challenge questionable brand patents and start competing with the branded companies if they win. And that trade-off was 180 days of generic exclusivity. In that way, generic companies were supposed to protect consumers from unwarranted patent monopoly pricing by branded companies. But reverse payment settlements frustrate the purpose of Hatch-Waxman in two ways. First, the settlements incentivize the generic to abandon the patent challenge, leaving a suspect patent intact for the entire extended patent period. Second, they can incentivize the generic to challenge patents that shouldn't be challenged in hopes of getting paid off for settlement. In other words, these anti-competitive settlements have ended up vitiating the incentives for generics to protect consumers, and instead can result in generics feathering their own nests. By virtue of the reverse payment settlement agreement, the brand stops the generics challenge and so it doesn't lose its patent monopoly, even if its patent is invalid or not infringed. The generic, meanwhile, gets a share of the brand's monopoly profit in the form of the reverse payment. But the consumer, including the federal government, as has been pointed out, ends up being a huge loser, since consumers continue to pay monopoly profits until the generic starts to compete. This is demonstrated by the pie chart on page 12 of the Commission's written remarks. And a good example is our Cephalon case, where the CEO of the brand boasted that his deals generated an additional $4 billion in sales. Most of the profits from those sales will come from consumers' pockets. Now imagine if there are 10, 15, or even more of these settlements each year. Beyond that, on their face, reverse payment agreements are market division agreements between potential competitors. That's why the Sixth Circuit in the Cardism case held that they were per se illegal. And that holding is consistent with the 1990 Supreme Court Palmer decision, which held that market division agreements between potential competitors are per se illegal. So reverse payment agreements not only violate the purpose of Hatch-Waxman, but also seemingly violate the Palmer holding. So why am I here, supporting congressional legislation? Well, recent circuit court decisions have ignored Palmer and Cardism, substituting their own judicial policy judgments that market division agreements should be permissible to settle patent litigation. For example, the 11th Circuit's Shearing decision, in which the circuit court declined to follow Palmer or Cardism, emphasized that its decision was based on, quote, policy, end quote. But Congress is the body with the responsibility to set patent policy. In short, the courts have disturbed the balance that Congress struck in Hatch-Waxman by permitting reverse payment settlement agreements, and Congress should correct that imbalance. Congress shouldn't wait for the Supreme Court to review these erroneous judicial decisions either. There's no reason to think that the court will set things right anytime soon. It's declined to review both Shearing and tamoxifen, which followed Shearing, that's the Second Circuit decision, and the petition currently before the court in the Cipro case, the most recent of these decisions. In that petition, the petitioner actually suggests that the Supreme Court defer ruling on the petition until the parties file a petition in a parallel action. More important, however, Cipro represents the extreme case. It holds that reverse payment settlements are, in effect, per se legal, not illegal, but per se legal. Even if the court concludes that Cipro is wrong and that reverse payment agreements are not per se legal, that still leaves open the question whether, as Shearing and tamoxifen held, the strength of the patent is a threshold issue that has to be litigated before the public or private plaintiff can litigate the antitrust merits. I've said publicly, Mr. Chairman, that litigating the strength of the patent may be one way to avoid Shearing and tamoxifen, but I'll be the first to admit that that may be costly and duplicative. Hatch-Waxman contemplated that the generic would litigate the strength of the
Mr.
patent.
Commissioner, would you please bring your comments to a close? You're a minute and 47 seconds over your time.
Okay. Can I just conclude by saying, Mr. Chairman, that at the Commission at least, this is not a partisan issue. 11 members of the Commission over the years that this has been at issue, all the Republicans, all of the Democrats have joined in these cases, and all four of us, 2 Republicans and 2 Democrats who are currently on the Commission, strongly support the legislation that is before the committee. Thank you.
Thank you very much. Now the chair recognizes the gentleman, Mr. Scott Hemphill, for 5 minutes or thereabouts for the purposes of an opening statement.
Thank you. Chairman Rush, Congressman Stearns, and members of the subcommittee, I'm Scott Hemphill, an associate professor at Columbia Law School. My scholarship and teaching focus on the balance between innovation and competition established by antitrust law, intellectual property, and regulation. I thank you for the opportunity to testify today about anti-competitive pay-for-delay agreements between brand-name drug makers and their generic rivals. These remarks draw upon my ongoing academic research into the economic effects of these settlements and their appropriate legal treatment. Most recently, an article forthcoming in the Columbia Law Review. I hope these articles might be included in the hearing record.
So ordered.
I've advised the Federal Trade Commission on the antitrust issues raised by pay-for-delay settlements, but the views I express today are mine alone. For 25 years, the Hatch-Waxman Act has provided a way for generic drug makers to introduce a competing version of a patented brand-name drug, even before the relevant patent or patents expire, by arguing that the patent is invalid or not infringed. The generic firm has a large incentive to do this. 180 days of exclusive sales, free from generic competition when it later enters the market. Usually the brand name firm files a patent infringement suit in response. Often, the generic firm wins the suit, and when it does, drug prices fall. But sometimes the brand name firm, instead of taking that chance, decides to settle the suit. The parties dismiss the suit and agree on a particular date when the generic firm can enter the market. That date is the result of a hard bargain between the two companies. The brand name firm pushes for as late a date as possible, arguing that it's likely to win the case at trial if put to the test. The more persuasive that argument is, the later the entry date. Now, such a settlement which rests solely upon the inherent strength of the patent is properly permitted, but now think what happens when a brand name firm instead makes a payment to the generic firm, rather than relying solely on its prospects at trial. In that case, the payment secures a later date than is warranted by the likely validity of the patent alone. That payment to a rival made to secure additional delay in generic entry ought to be prohibited. This pay-for-delay settlement problem is growing. To get a better sense of the problem, I collected a data set using public information of 143 brand generic settlements between 1984 and August 2008. Of these, 60 settlements raise pay-for-delay issues. Settlements as to just 10 drugs whose form is particularly troubling and which currently block generic entry account for U.S. sales of about $17 billion each year. The problem is not just growing worse, it's also getting harder. In the early days of pay-for-delay settlements, the brand name paid cash, a couple $100 million in the case of the antibiotic Cipro. These deals are, relatively speaking, easy to understand. But today, firms also pay by making contemporaneous side deals that help to disguise the payment. And they can even use the 180-day period I mentioned a moment ago as a source of payment. Let me explain. A generic firm gets the 180 days if it fights the patent and wins. It loses the 180 days if it fights the patent and loses. But what if it settles? In that case, it keeps the 180 days. Now, this is important because it means that a brand name firm can approach the generic and say, let me keep my patent, and in exchange, I'll let you have the 180 days, just much later. For a blockbuster drug such as Lipitor, such forbearance is worth hundreds of millions of dollars to a generic firm. The current approach to pay-for-delay settlement is just not working. H.R. 1706 is an important step forward in identifying and deterring pay-for-delay settlement. Section 2A of the bill prohibits a settling brand name firm from providing a generic firm with, quote, anything of value beyond a negotiated entry date, and with a few specified exceptions. It's important that the subcommittee recognize that anything of value, properly understood, includes all forms of compensation that induce delay, including effective guarantees of exclusivity. The subcommittee might wish to make this point explicit in the bill. To conclude, the pay-for-delay problem is getting worse as new deals are made and as deal structures become more and more complicated. Congress can help by prohibiting these anti-competitive arrangements. Thanks are due to the subcommittee for taking a leadership role on this important issue. I look forward to hearing your questions and concerns.
The chair thanks the gentleman. Now the chair recognizes Ms. Joanne Hardy for 5 minutes for the purposes of an opening statement.
a member of the AARP board, also a nurse and a healthcare provider. On behalf of our more than 40 million members, thank you for the chance to testify about H.R. 1706. AARP has endorsed this legislation, and we call on Congress to enact this legislation this year. Older Americans, as has been referred to several times by members of the subcommittee, use prescription drugs more than any other segment of the U.S. population. Unfortunately, the costs for brand name drug products continue to rise at rates that far exceed inflation, causing a strain on the budgets of both consumers and other healthcare payers, including the government. Spiraling drug costs are particularly hard for older adults who are disproportionately affected by chronic disease and more likely to need multiple medications. When faced with higher drug costs, they frequently skip doses, reduce doses, and let prescriptions go unfilled. The result is preventable and expensive hospitalizations and adverse health outcomes. This occurs far less often for those taking generic drugs, which have proven to be one of the safest and most effective ways for consumers to lower their prescription drug costs. AARP encourages its members to use generic drugs whenever possible. AARP strongly supports efforts that provide timely market entry of generic drugs. We are concerned, however, about the recent trends in reverse payments, which occurs when generic manufacturers receive anything of value in exchange for agreeing not to research, develop, manufacture, or sell its generic products. These reverse payments delay market entry of new generic drugs and thus increase the odds that older Americans will be forced to cut back or go without needed medicines because of the rising cost. AARP believes that H.R. 1706 is an appropriate remedy to end the problem of reverse payments. This legislation is needed because when brand and generic pharmaceutical companies engage in conduct that delays market entry of generic drugs, consumers and other healthcare payers pay higher prices. And as a result, older Americans are more likely to go without the drugs they need because of the higher cost. Stopping or delaying market entry of the first generic drug prevents all the other generic drugs from competing and ultimately extends the brand name manufacturer's market exclusivity. This creates a powerful incentive for companies to negotiate, to collude with the first-to-file generic manufacturer to delay market entry of the generic product. Legislation is necessary because, as you've heard, there have been recent court decisions that have held that reverse payment agreements do not violate the antitrust laws. These decisions have unquestionably led to an increase of such agreements and hampered the Federal Trade Commission's ability to prevent these abuses. In fact, the FTC has reported a marked increase in the number of questionable settlements. 50% of the 2006 settlement agreements between brand and generic manufacturers included some form of payment as well as an agreement to delay market entry. Ending these costly patient abuses is one essential component in our efforts to reduce skyrocketing brand name drug prices and provide affordable, comprehensive health care options to all Americans. Again, AARP strongly supports H.R. 1706. We are pleased to see the committee and members from both houses of Congress and both sides of the aisle moving forward on this issue. Thank you for inviting us to be here.
Thank you. Now the chair recognizes Ms. Diane Berry, who's the General Counsel for Pharma, for 5 minutes for the purposes of opening statement. Welcome.
Thank you. Chairman Rush, Congressman Stearns, and members of the subcommittee. Thank you for the invitation to participate in today's hearing on legislation that could have a significant impact on pharmaceutical companies' settlements of patent disputes. My name is Diane Beery, and I'm the Executive Vice President and General Counsel of Pharma. In 2008 alone, Pharma members, including both large and small biotech and pharmaceutical companies, invested more than $50 billion in discovering and developing new medicines. What's more, roughly 70% of this research was made right here in the United States, representing a significant number of American jobs and other contributions to the economy. In the past 10 years, over 300 new medicines have made it through the increasingly complex FDA review process and into the hands of physicians and patients. These new medicines are increasing life expectancy, decreasing disability, and providing hope to patients and their loved ones who are fighting life-threatening and debilitating diseases such as cancer, cardiovascular disease, diabetes, rheumatoid arthritis, and many others. America's biopharmaceutical companies are facing more challenges than ever in terms of bringing new medicines to market. It takes, on average, 10 to 15 years and more than $1 billion to bring one new medicine to patients. That is why research-based companies and their investors need to be confident that the law will respect and uphold the critical role of intellectual property, including patents, in providing the opportunity to recoup these substantial investments. Patent protection is the engine that allows America's research-based biopharmaceutical companies to take risks and strive to develop the next generation of life-saving and life-enhancing treatments. Of course, it is important to remember that pharmaceutical products effectively have a shorter period of patent life than other types of products. Pharmaceutical companies must obtain FDA approval before marketing their products, and much of the patent term is spent before the medicine actually comes to market. Recognizing these challenges, the Hatch-Waxman Act of 1984 attempted to balance the interests of both innovative and generic companies. The law made it easier for generics to come to market, but also restored to innovators some of the patent time lost during the clinical research and regulatory review process. But even after Hatch-Waxman, the useful patent life of a pharmaceutical product is limited. For example, one study showed that for medicines whose generic competitors entered the market between 2002 and 2005, the average time on the market before generic competition was only 11.2 years. In addition, you have to look at the tremendous increase in competition between brand medicines, but particularly between brand medicines and generics. Since passage of Hatch-Waxman, the generic industry share of the prescription drug market has jumped from less than 20% to over 71% today. This is, of course, due in part to the fact that Hatch-Waxman has spawned more patent challenges, as it was meant to do. Hatch-Waxman gives generic companies incentives to challenge patents as soon as 4 years after the brand medicine receives FDA approval, without requiring the generic to take the risk of actually marketing the product before the patent challenge is resolved. Given this construct, patent challenges have become commonplace. But patent litigation is still lengthy, expensive, and risky for all concerned. Generic companies do not have perfect information when they bring challenges, and brand companies cannot be sure their view of the strength of their patents will carry the day at trial. The rapid expansion in generic utilization has been fueled in part by the fact that innovators and generics have had the flexibility to resolve some of these patent suits in fair and appropriate ways without taking every case the whole way through trial and appeal. There is no doubt that H.R. 1706 would significantly reduce that flexibility. Courts and experts tell us that patent settlements between brand and generic companies, even those that include some payment from the brand to the generic, can benefit consumers. Yet H.R. 1706 would prohibit a wide variety of patent settlements just because the brand company transfers something of value to the generic. This kind of broad ban would chill all patent settlements and is likely to reduce innovation and also reduce the number of patent challenges filed. Broad limits on options for patent settlements would force both sides to spend valuable resources litigating rather than developing new medicines or bringing generic versions to market. Statistics from recent years show that innovators are likely to win over 50% of the cases litigated through appeal, which means that generic entry in those cases would not come until the patent expires. In contrast, a settlement might include provisions allowing a generic product to come to market well before the patent expires and could produce other collateral benefits, such as licenses for generics to market products unrelated to the patent dispute. Instead of a blanket rule banning certain types of patent settlements, enforcement agencies and courts should continue to evaluate settlements on a case-by-case basis to determine whether, on the whole, they benefit consumers. The Medicare Drug Improvement and Modernization Act of 2003 enhanced the FTC and Department of Justice's ability to make those determinations. This approach preserves the delicate balance between intellectual property protection that fosters innovation and competition principles that encourage access to generic medicines and a strong, healthy generic industry. I look forward to answering any questions you may have, and PhRMA looks forward to working with you on this legislation. Thank you again for your attention to these important policy issues.
The chair thanks Ms. Berry, and it's now my honor to introduce and to allow Dr. Barry Sullivan 5 minutes for the purposes of opening. Sherman, I'm sorry. Sherman, 5 minutes for the purposes of opening statement. Dr. Sherman, you're recognized for 5 minutes.
Okay. Mr. Chairman, members of the subcommittee, thank you for the opportunity to testify again today. Apotex Inc. is very eager to do its job of challenging weak patents and bringing to the market products as quickly as possible for the benefit of our customers, who are the pharmacy industry of America, and through them to American consumers. We are therefore eager to help elucidate the fundamental problem that is blocking generic entry, and that, in our view, is settlements by first filers that whereby they accept unduly late, very late entry dates, keep their exclusivity, and thereby block market entry to others such as us who would continue to fight and thereby gain much earlier market entry. And the cost to the American consumer is enormous, billions of dollars for individual products, and certainly many tens of billions of dollars in total. One example is the drug modafinil, whereby the Cephalon settled with 4 generic suppliers, challengers, some years ago, and thereby got delayed generic entry until the year 2012. The patent is very weak. We would be prepared to launch the product now if we could, and indeed in Canada, we've already succeeded in the patent challenge, and the product is on the market in Canada as a generic sold by Apotex. So the problem is quite enormous. There have been legislative initiatives, including this one, to address the problem by trying to prohibit reverse payments, settlements that include reverse payments. In our view, reverse payments per se are not the problem. They're simply a symptom of a problem. Why are brand companies prepared to make large payments? It's not because they are fair payments to the particular company with whom they are settling. It's because when they settle with the first filer, they know the first filer retains the exclusivity and blocks all others. So they are paying not because, not to get the one settlement, to get the entire block of the market until near patent expiry, and that is the fundamental problem. In our view, there are 2 flaws that need to be addressed and can easily be addressed. The first is that the first filer who settles and doesn't do what was intended by the Hatch-Waxman provision gets to keep that exclusivity to block all others. And the second problem is that these agreements almost always contain poison pill provisions, whereby if a subsequent filer does succeed to get early entry, the settler simply accelerates entry and takes away the benefit to the subsequent filer who actually succeeded. One example that brings the point home is the case of Altace Ramipril. The first filer was Cobalt. They settled for very late entry, but in 2007, Lupin won, even though they were not the first filer, won in the Court of Appeal. What then happened? Cobalt used its poison pill provision to accelerate its entry, launched the product, and Lupin could not launch, even though they were the ones who invested and won. So all of the benefit went to Cobalt, who had settled. None of the benefit went to the successful litigant who was not the first filer. The message from that case is clear to all who would subsequently challenge a patent: don't do it, it isn't worth it, you can't succeed. So the effect is that the litigation by those who would actually fight to win is paralyzed. In our view, there are 2 simple amendments that are needed to fix this problem. The first amendment is to give a shared exclusivity to a subsequent filer who does fight and wins. And the second provision that is needed is to override the poison pill provisions, which would, in essence, provide that if a first filer settles for very late entry, FDA can then not give final approval to that first filer until that date, and that date can then not be accelerated by reason of a subsequent win by a subsequent filer. These 2 provisions would accomplish 2 very important things. Number one, it would give, when there is an anti-competitive settlement whereby a first filer has agreed to defer to a very late entry date, it would give an incentive to a subsequent filer to pick up the battle, challenge the patent, and win and get earlier entry. And the second effect would be that it would eliminate the anti-competitive settlements, because if these provisions were enacted, a brand company would no longer make a reverse payment to a first filer because it wouldn't have the effect of blocking all challengers. It would only block the one, and therefore there would be no reason to make that big payment. And secondly, it would tell the first filer that it shouldn't settle for too late a date, because if it does, it will be stuck with that date, and then we'll lose the opportunity to launch if a second filer, a subsequent filer, wins an earlier entry date. So in our view, the attacking or trying to eliminate reverse payments really will not solve the problem. This anti-competitive settlements will continue with the same anti-competitive effect, only without the reverse payments. And what is necessary to address the problem is to give shared exclusivity to a subsequent filer who does take up the battle and wins, and to eliminate the poison pill provisions whereby a first filer who agrees to late market entry can then accelerate that entry on the basis of an earlier win by someone who does invest in the challenge and wins. We very much urge the committee, the subcommittee, to consider our suggestions, because we've been at this for a very long time. We understand what the issues are. We're fighting the battles every day. We are most eager to do the job which the Hatch-Waxman provisions incentivized us to do, to fight, to win, to bring products to market early. We are blocked by these anti-competitive settlements, and these are the changes that we are convinced are needed to solve the problem. Thank you very much.
The Chair, thanks, gentlemen. Now, the last witness, the Chair recognizes for 5 minutes. Mr. Whitehouse, you're recognized now for 5 minutes for the purposes of opening statement.
Thank you. Chairman Rush and Congressman Stearns and members of the subcommittee, good morning. I am Ted Whitehouse. By now it's good afternoon. I'm a partner at Wilkie Farr & Gallagher and appearing today on behalf of Teva Pharmaceuticals, which, as you know, is a leading pharmaceutical company that participates both on the generic and the brand sides of the industry. Teva and I appreciate the opportunity to appear and be heard on these important issues. As I think you know, Teva has been an active participant in the last Congress and in the current Congress in the deliberations and on the matters at issue in this hearing. We hope it has been apparent to everyone that Teva is very concerned about this and similar legislative proposals, but also very willing to work constructively with Congress and the FTC in an effort to ensure that the concerns being raised here are addressed without doing harm to the vital concerns and incentives at the heart of Hatch-Waxman. Teva believes that the intricately crafted Hatch-Waxman process that Congress put in place 25 years ago has worked and is working very well. Teva's basic position is that no new legislation is needed. Teva is therefore opposed to H.R. 1706. Teva believes the ability to reach reasonable, timely, and pro-consumer settlements in Hatch-Waxman Paragraph 4 litigations is absolutely essential to Teva's effort to bring low-cost generic drugs to market as soon as possible. And that is Teva's fundamental business, to work to bring products to market as soon as possible. From the perspective of consumers, settlements that result in bringing products to market sooner and with more certainty than might otherwise be the case are a very good thing. Teva believes that the members and staff should give particular attention to a recent paper written by 3 prominent economists, including Dr. Laura DeAndrea Tyson, a professor of economics at Berkeley who served as chair of the Council of Economic Advisors and as director of the National Economic Council in the Clinton administration. She's joining the Obama administration to advise on tax policy, as we understand it. This paper, copies of which we believe have been distributed to all members and their staff, confirms, on the basis of economic analysis and theory, some of the conclusions that Teva reached from its practical experience. First, that settlements can be good for consumers. Second, that reasonable settlements are more likely to be achieved if parties have more than 1 or 2 issues over which to bargain. And third, the paper emphasizes the importance of case-by-case analysis of settlements rather than a blanket ban on particular terms. As Dr. Tyson's co-author said in a letter sent yesterday to the chair and ranking member, quote, "A broad ban on certain types of patent settlements, such as that considered in the proposed legislation, will likely make American consumers worse off." Teva does not contend that all Hatch-Waxman settlements are necessarily good for consumers, but it takes strong issue with the legislation that would have prevented Teva from engaging in any of the recent settlements that Teva reached that produced real benefits for consumers. For example, 10 settlements entered into by Teva between 1999 and 2007 took approximately 80 years off the lives of the patents in issue and will end up saving consumers more than $67 billion. Teva believes that more serious consideration should be given to legislative alternatives that were extensively discussed in the last Congress, such as mandatory expedited review by the courts or a more formal expedited FTC pre-effectiveness review process. If the subcommittee determines to proceed with the approach embodied in H.R. 1706, Teva strongly urges that the exceptions or carve-outs in the bill be broadened to make clear that at least the kinds of terms that Teva has successfully employed in the past to reach settlements that produced real benefits for consumers remain permissible. And those provisions include, among other things, early generic entry on other products, in addition to the one in suit, a full release for damages and a covenant not to sue on all patents on the generic products involved in the settlement, a limited exclusive license, and case-by-case authority for the FTC. Now, most of H.R. 1706 is directed to patent settlements. However, Section 4 addresses a different set of issues, not tied or limited to patent settlements. Essentially, Section 4 would broaden the circumstances under which the first generic company to challenge a brand company's patents could lose or forfeit the 180 days of marketing exclusivity provided to first filers under Hatch-Waxman. As you've heard today, there are people in the industry who don't like the 180-day exclusivity provisions, but it is important to be very clear that those provisions have been in Hatch-Waxman from the start and are absolutely central to the incentive structure that has brought this country the vibrantly competitive and publicly beneficial generic drug industry from which consumers, third-party payers, and the federal and state governments benefit every day. I respectfully invite your attention to my written statement for a full explanation of Teva's concerns relating to these complex provisions in Section 4. But very briefly, by way of example, as written, subsection CC would result in forfeitures of exclusivity before anyone has been cleared to enter the market. Proposed subsection DD, we believe, is confusingly unclear and potentially very overbroad. On all of these issues, Teva hopes to continue an active and constructive dialogue with members of Congress and their staffs, and with FTC commissioners and the FTC staff, all with a view to trying to address any legitimate concerns while carefully preserving all that is good and necessary about the existing and highly successful Hatch-Waxman process. Thank you very much. I'd be pleased to answer any questions that you may have.